Kia ora. Thank you to Claudia and Dean for inviting me today. It's a real honor to speak with you. So when the temperature dips below -20, Canadian administrative law types hunker down to engage in one of their favorite indoor pastimes, finding ways to make administrative law doctrine even more arcane and convoluted than it already is. And this is what brings me to the topic of standard of review and deference. In the next few minutes, I'll try to answer two questions. What is judicial deference about in Canadian administrative law, and why should a New Zealand lawyer care? Judicial deference proceeds from the idea that judges can bring different levels or intensity of scrutiny to their review of administrative action. Deference encourages a kind of reflexivity among judges. Rather than simply proceed to resolve the legal issue before them, a judge should first pause and ask herself, am I really better positioned to answer this question than the original decision maker? And if the question isn't obviously yes, maybe I should defer to that original decision maker. And what that means is to refrain from intervening unless the decision is unreasonable. An unreasonable decision is not simply a decision that a judge disagrees with. Instead, deference amounts to something like putting a thumb on the scale in favor of the original decision maker. A judge may yet set aside the decision, but only if it falls below a standard of rationality, intelligibility, or justification that goes under the name reasonableness. But why should a judge do that? Well, there are good reasons for deference. Administrative actors may indeed have different or greater knowledge or expertise about their field and the policy context in which they execute their statutory mandate than does a judge. Well, sometimes the tasks given to administrative actors look like something courts can do or have done in the past, but sometimes they do call on a different skill set, a different kind of knowledge, or perhaps just the kind of ongoing immersive experience that generalist judges engaging in one-off decision-making cannot match. So rather than courts regarding themselves as the sole guardians of the rule of law against the encroachment of an unruly or unrestrained administration, we could instead understand administrative actors as partners in the rule of law project and proceed from a posture of due regard or cooperation rather than suspicion or condescension. Of course, having said all of that, sometimes judges really are better situated to make a determination, perhaps because of their independence or their specific legal expertise, or because of their broader horizons. Sometimes judges, for example, have a concern or attention to individual rights that an administrative actor charged with administering a particular statutory mandate doesn't have. So even if one accepts the deference is appropriate in some, many, but not all circumstances, one is left to resolve two questions. When is deference warranted and when isn't it? And secondly, how is deference operationalized? How does one do deference? In the last 10 or 12 years, most of the emphasis in Canadian law has been on the second question. How does one operationalize deference? And that's because the Canadian Supreme Court has tilted rather strongly in the direction of all deference all the time, putting the pressure then, or most of the emphasis, on the how rather than the whether to defer. Now, without dragging you through the muck of Canadian jurisprudence over the last 40 or so years, suffice it to say that there are recurring themes and dilemmas that have emerged. Judges are not generally known for their modesty, and deference doesn't really come easily to some of them, even as they say they are deferring. On the other side, administrative actors aren't uniformly competent, expert, or sensitive to the larger context in which they operate or the individuals who appear before them, and so the presuppositions in favor of deferring to them are not always fulfilled. So deference emerged when the perceived problem was a conservative judiciary thwarting legislative intent to advance reformist agendas via the administrative state, such as a labor relations regime or income redistribution. Deference was a solution to the problem of conservative judges, for example, continuously doing end runs over privative clauses. Fast forward, though, to the 21st century, and the paradigmatic case is no longer about labor relations, but, for example, immigration law. a topic that I think you will hear coming from lots of different jurisdictions, the United States, Canada, and Australia, in addition to New Zealand. And in cases involving non-citizens confronting a hostile bureaucracy backed up by a legislator that is not politically accountable to a disenfranchised migrant, advocating for judicial deference reads differently. Now, beyond the politics of deference, the practical challenge is that courts in Canada have not succeeded thus far in devising a stable, predictable, workable methodology for determining when to defer and especially how to defer. How does deferential statutory interpretation look any different from an enlightened approach to ordinary statutory interpretation? How does an unreasonable exercise of discretion look different than, for example, an unlawful exercise of discretion that fails to take a relevant factor into account? If one can't distinguish between these approaches, then how does one differentiate between a deferential posture and a non-deferential posture? Like many academics, I'm sympathetic to the theory and the project of deference, even as I despair of its realization in practice thus far in Canada. So the bottom line I want to leave you with in New Zealand is both a commendation of deference and a cautionary note. Judicial deference as ethos has a lot going for it. Judicial deference as method still has a long ways to go. Thank you for your attention and your time. I wish you a very successful conference.